Welcome back to Hardball. Senator Chuck Schumer calls it a constitutional crisis. The Bush administration has decided to exert even more presidential authority in the ongoing U.S. attorney scandal, saying that Congress will never be able to bring contempt charges against White House officials. Has President Bush taken executive privilege too far? And will Americans sit back while an unpopular president tries to expand the powers of his office? That's our Hardball debate tonight. Mark Green is the president of Air America and a public interest lawyer. And David Rivkin was former justice official under President Reagan. Mark, let me ask you, reading the papers, it seems to me, I'm not a lawyer, and I don't even play one on TV, but it seems to me that the President of the United States just asserted that no matter what you say, no matter what you do, while you're working for the President of the United States, he, as President, has the ability to say, that guy, that woman, doesn't have to testify before Congress because I invoke executive privilege. Am I correct?
It's good you're not a lawyer, because you're right. George W. Nixon is picking up where Richard Nixon left off. Look, the context is important. The same people who apologized for torture, who said warrantless wiretapping was okay, which said that Dick Cheney is not part of the executive branch, now claim an absolute executive privilege, which of course is not in the Constitution, is not in statutory law, is court-made law. Now, presidents have to be free to converse with staff without any fishing expedition going after them, except if there's evidence of wrongdoing or illegal conduct. That was in the Nixon case. And finally, in two cases in the Clinton era, if a lawful investigative body in the Congress needs information it can't get anywhere else, then a person paid by taxpayers should come before Congress in a system of checks and balances. This government are radical reactionaries who have a monarchical concept. George Bush is closer to King George than George Washington when it comes to the rule of law.
David?
Mark cannot be more wrong. Let me make a couple of points. First of all, Congress is not stymied here. The way those issues are supposed to be resolved is Congress asks for documents, issues a subpoena. The executive branch, after due deliberation, have the president decide that producing particular documents would impede his ability, institutional ability, to get unfettered advice. His is not the last say. Congress is not the last say. Congress goes to district court and seeks to enforce subpoena. In the end of the day, if the judiciary agrees with Congress, the subpoena is enforced, and the contempt is issued by the court if there is disobedience. Or the court finds, if I may,
courts find through the courts.
Well, it takes a number of months, but that's the way things are supposed to work. What's utterly inappropriate here is for Congress to take the position that they have a final say in this matter and issue a contempt citation against an individual executive branch official whose only malfeasance is that he or she is following the president's edict here, and it's the president's word. But that is the only thing that has happened here. There's nothing unprecedented about it. It has happened in the past, and with all due respect to Mark, if you do not give a president an ability to protect internal executive branch deliberations, which by the way Congress and the judiciary do, you are not going to have a functioning executive branch.
What David leaves out, what he fundamentally leaves out is, I agree, Congress has to go and the executive has to go to court to decide it. The problem here is that Bush, in effect, is pardoning himself. He announced that his U.S. attorney, a Republican appointee of President Bush for the District of Columbia, who has to prosecute a contempt of Congress citation, won't do it. Almost no power of the president is unlimited. We all thought that pardon and commutation were unlimited in the recent debate. Not true.
Mark, forgive me, you are deliberately...
One last sentence. A president can pardon himself after impeachment. That's in the Constitution. He is exonerating himself by not allowing his appointee to prosecute contempt of Congress.
That has nothing to do with pardons. We have a 1984 Office of Legal Counsel opinion that makes it very clear that you are not going to have a situation where Congress presumptively criminally condemns.
Who wrote that?
It was written by the head of Office of Legal Counsel, Ted Olson.
Under President Reagan?
But look,
it's not law.
It has...
Bruce Fine, who was in the Reagan administration, disagrees with you.
The way those issues are resolved is Congress issues a subpoena, Congress goes to court to enforce it. There is no implication that either branch is right or wrong. A neutral arbiter, an Article III judge, resolves it, and one branch or the other prevails. What Congress seeks to do is short-circuit this process and condemn an individual executive branch official, which is frankly unprecedented and extremely regrettable.
Hey, Mark, we're we're running out of time here, but let me ask you, what do you think the odds are that the next president, no matter who it is, no matter who it is, Democrat or Republican, will try to hold on to this power that the Bush administration has accrued to the presidency?
This is radical. Bruce Fein, who was with President Reagan, disagrees with my opponent here. The Congressional Research Service disagrees. This is not a left or right issue. I assume if the next president is a Democrat, when they take the oath of office to faithfully execute the laws, they'll assume it means what it says. President Bush thought execute the laws, and he took it literally. This is a lawless administration, from Geneva Convention to warrantless wiretapping. So we're having a nice debate. But the context is they don't believe in the rule of law, and he's trying to exonerate himself by not prosecuting a contempt citation.
Go ahead, quickly.
Totally
David.
wrong. There is nothing peculiar to this administration. This is protection of institutional prerogatives of a presidency. And what you are talking about is making the president a ward of Congress that no president, Republican or Democrat, in the history of this republic can ever accept.
Mark Green and a very snappily addressed David Rivkin, we thank you both. Up next,
What's
our
wrong with
Hardball
this?
panel.